On January 31st, the United Kingdom left the EU as part of Brexit. Since then, there has been a transition period that expires at the end of 2020. This transition period, during which everything initially remained the same, is to be used to negotiate the contracts required to regulate future relationships. This also includes clarifying the data protection situation in the UK from 2021 onwards. However, the already sluggish negotiations were further delayed by the corona pandemic, so that an agreement until the end of 2020 is uncertain. Although there was an option to extend the transition period, the British government did not take this option. While the end of the transition period is closing, the United Kingdom will be a third country in terms of data protection from January 1st. And that includes the transmission of personal data, for example. Contractual partners, group companies or service providers based in third countries have additional requirements under the EU General Data Protection Regulations, the GDPR. Therefore, all companies should now use the remaining time until the end of the year to create the data protection framework for their data transfers to the United Kingdom. Why is this so? The United Kingdom left the European Union on January 31st, as I said. Since then, there has been a transition period, but that will expire. This transition period, nobody did what really was supposed to be, because right now we should have a new agreement. And this also includes clarifying data protection. But why does Brexit have an effect on data protection law? To answer this question, it's important to understand the scope of the General Data Protection Regulation. Because unlike in the past, when every European member state passed its own national data protection laws, the GDPR applies equally in all member states of the EU. This has the advantage that there are no additional legal requirements for cross-border data transfers within the EU, but only the same GDPR. The same applies to the European Economic Area, which also includes the three states Iceland, Liechtenstein and Norway. Countries that are outside the EA are referred to as third countries under data protection law and are not subject to the GDPR and have their own data protection laws. In order not to jeopardize the uniform data protection standard by companies outsourcing their processes to third countries with weak data protection laws, the GDPR only allows data transfers to such third countries under certain conditions. If Brexit is over at the end of the transition period, the UK will also be considered a third country. Data transfers are then no longer easily possible, which is particularly challenging for companies with business partners or subsidiaries in the United Kingdom. To whom exactly does the GDPR apply? Modern digital data traffic is characterized by the fact that it largely ignores traditional national borders. At the push of a button, highly personal data can be sent around the world. The applicable laws are initially of secondary importance. This is precisely why it is particularly important for companies to have an overview of their own data processing operations. That means to know which data is actually affected, where the data is stored, and where business partners or service providers are located. These factors determine whether the GDPR applies to a specific processing operation. There are essentially two important points of reference for the GDPR area of application: the seat of the company responsible for data processing and the location of the person whose data is being processed. Put simply, the GDPR applies to all companies that have their headquarters within the Union or that, regardless of their place of business, address their offer to people in the Union and subsequently process their data. In order to prevent European companies from evading the strict data protection requirements of the GDPR, data may not simply be transmitted to third countries. The requirements for third country transfer are regulated in the GDPR. There are various legal instruments on the basis of which a transmission can be legitimized. The two most important instruments are the adequacy decision and the so-called standard data protection clauses. By means of an adequacy decision, the EU Commission determines that a third country guarantees an adequate level of data protection. Such decisions are usually preceded by intensive negotiations at government level. If a decision has been made for a third country, data can be transferred without further ado. This political solution is therefore the easiest for companies due to the lack of additional effort. The withdrawal agreement between the EU and the United Kingdom provides that the transition period should be used to draw up an adequacy decision, which can then be used as a basis for data transfers. In contrast, the standard data protection clauses are not agreed between states, but between individual companies. These clauses are included in the contractual relationship in addition to other contractual documents and bind the parties involved. The appropriate data protection standard is therefore contractually agreed between the parties. Apart from the fact that companies have to agree on the inclusion of the clauses, the effort remains low since the sample contracts are already finished, which are provided by the EU Commission and may not be changed. The so-called binding internal data protection regulations or binding corporate rules are another instrument to enable the legally secure transmission of data to third countries. However, this is not about data transfers between different companies, but within the same company, specifically large groups with subsidiaries in third countries. The BCR can be individually designed, but must also be approved by a data protection authority. Finally, the GDPR regulates a number of exceptional circumstances in which, in individual cases, data may be transmitted to third countries even without one of the aforementioned principles. What significance does the Schrems II ruling of the ECJ have? On July 16, 2020, the European Court of Justice, the ECJ, published a much-noticed judgment. Among other things, this ruling has implications for the negotiations between the EU and the UK on a possible adequacy decision. The subject of the judgment was a so-called privacy shield. This was the name of the EU's Commission's adequacy decision on the USA. The ECJ has declared the privacy shield agreement to be invalid because, despite this agreement, an adequate level of data protection cannot be guaranteed. The reason for this is primarily the far-reaching powers of American security authorities, which, regardless of the privacy shield, can access the data of EU citizens that are processed within the USA. The ECJ, on the other hand, considered the standard data protection clauses to be valid. However, the ECJ sees the companies referring to this as having an obligation to check whether the data protection requirements of the standard data protection clauses can actually be complied with when data is transferred to the USA. If this is not the case, the companies must stop their data processing or expect corresponding measures by the supervisory authorities. What that means legally and in practice for European companies has not yet been conclusively clarified. In any case, it is certain that many American companies, especially those in the telecommunications industry, cannot unilaterally evade US security laws through contractual agreements. As a result, there is currently extensive legal uncertainty. As long as the USA does not provide for exceptions for the personal data of EU citizens in its security legislation, neither a further adequacy decision nor standard data protection clauses appear to be a satisfactory solution. As the Trump administration has already stated that it is not interested in concessions, there will be no movement in the talks before the November elections. A final option for action remains for companies. The legal basis for data transmission to a third country can also be the express and informed consent of the person concerned. An adequacy decision for the United Kingdom would have to be measured against the same criteria that the ECJ applied to the privacy shield. Even if the security legislation of the British is not individually comparable with that of the Americans, there are still considerable concerns as to whether the data protection standard of the GDPR can be maintained in the long term. But what do the individual actors say? The Schrems II ruling has revived the negotiations between the EU Commission and the British government and, at least in data protection law, brought them out of the corona break and into the public. However, it's not yet entirely clear which direction will be taken. The British government originally took the view that nothing would stand in the way of an adequacy decision, as the data protection standard would remain the same regardless of Brexit. Similar to Germany with the Federal Data Protection Act, the United Kingdom has passed its own national law parallel to the GDPR, which transposes the essential provisions of the GDPR into national law. If the GDPR no longer applies in the UK with Brexit, at least a similarly strong national data protection law would remain, which is a good basis for an adequacy decision. Nevertheless, the British government changed its course at the end of summer 2020. At the beginning of September 2020, a new data strategy was presented, which is intended to significantly lower data protection standards in order to attract companies to the United Kingdom. Most recently, the government has called the GDPR terrible and business hostile. In addition, the Prime Minister Boris Johnson tried to unilaterally break the previous exit agreement. The course of the British government has caused astonishment in the EU as well as in the UK itself. An adequacy decision, which seemed unlikely anyway due to the long deadline schedule, has now moved a long way off. The EU Commission is still interested in the conclusion of the Brexit negotiations, but since the Schrems II ruling at the latest, the issue of data protection adequacy decision has slipped down on the agenda. After the so-called Safe Harbour Agreement, the Privacy Shield was the second EU-US adequacy decision that was overturned by the ECJ. The EU Parliament and data protectionists have therefore repeatedly criticized the Commission for disregarding applicable law in favor of economic interests. And I just have to add at this point, a lot of Brexiteers are saying the ECJ is just a tool of the Commission. Here the ECJ kicked the Commission in the bottom twice, and you still want to claim they're a tool of the Commission? Well, let's go ahead. It's therefore not unlikely that the EU Commission will omit the subject in the turbulent Brexit negotiations or even completely exclude it in order to show strength. The British Data Protection Authority, the Information Commissioner's Office, is trying to be restrained in contrast to the British government. The authority has a good reputation and has taken strong action in the past in the event of data protection violations based on the GDPR. On its side, the ICO provides a great deal of assistance for British and European companies in order to be prepared for every outcome of the negotiations. With regard to the data protection standard after the transition period, the ICO continues to refer to its general guidelines on the GDPR as there would be no significant changes. The highest European data protection authority, the European Data Protection Committee, is currently waiting for a signal from the EU Commission regarding a possible adequacy decision. As a result of the Schrems II ruling, however, concerns have already been voiced as to whether such a decision would make sense at all. For this reason, reference is still made to the guidelines and FAQs that the EDSA drafted in 2019 in the event of a no-deal Brexit. This primarily refers to the standard data protection clauses as the method of choice. In addition, in July 2020, the EDSA issued an information note for international corporations that deal with binding corporate rules. Apart from general assistance, the German data protection authorities have largely stayed out of the political discourse surrounding Brexit. The European Union has so far presented itself very uniformly on Brexit issues, which is why the German supervisory authorities are no longer likely to intervene. What must be expected, however, is that the supervisory authorities will enforce the respective legal situations from January 1st. Another transition period for companies or similar? No, there won't be. What does it all mean for a company and how can you prepare for this? All of this leads to the final question of how companies should react now. An adequacy decision is still not ruled out, but unlikely. Even if the EU Commission were to issue an adequacy decision, its validity is likely to be questioned as a result of the Schrems II judgment. Corresponding lawsuits are likely then. Of course, the EU Commission can still pass an adequacy decision after the end of the transition period. The current discussion in the context of Brexit only means that alternative legal basis for data transfer would have to be found at least from January 1st until a possible future adequacy decision. In any case, companies should prepare for the end of the transition period. Above all, this means creating an overview of your own data processing operations. Every process should be checked for possible contact with third countries. Not only direct data transfers to a company in the UK are relevant, but also transfers via multiple parties. This applies in particular to order processing. Not only the order processor must guarantee compliance with the GDPR, but also any subcontractors and all other subcontractors in the chain. Due to the Schrems II ruling, companies are currently required to check their data transfers anyway. Here at least two things can be tackled at the same time. If data transfers to the UK are identified, the legal basis should be checked. Communication with British business partners is worthwhile here. For companies in the United Kingdom, Brexit will have far greater consequences, which is why it is to be expected that British companies will already take precautions in terms of data protection law. I hope so. At the same time, it's recommended dealing with the standard data protection clauses. These model contracts could play an even bigger role in the future and should not be neglected. In addition, the exceptions the GDPR deserve a look for you, as there could well be practical cases depending on the company and industry. In an emergency, it might also be advisable to keep the option of consent open as the last option. Then the persons affected by the data transfers would have to be asked for their consent before the transfer. However, consent is only effective if the person giving consent has been informed of the specific circumstances and has expressly consented. Such consent should always be verifiable, which is why this option can be very time-consuming depending on the practical application. Finally, the question arises of how to deal with data that was transmitted before the end of the transition period. That means that was still legally transmitted. Because data processing operations are rarely selective, which is why it's practically difficult to make a temporal turning point. However, this case is regulated by the exit agreement between the EU and the United Kingdom. According to this, British companies are obliged to apply to the GDPR to data of EU citizens that were transmitted before December 31st, even after December 31st. European companies do not have to stop their data processing early, but enjoy GDPR protection until the end of the transition period. And before I continue, I know you know that I really don't do stuff like this usually. But on a topic like this, which is really complicated, and a long video like this, I really would be interested which of my viewers are really watching a long video like this. I am really curious about this. So you've seen my newest Star Wars Lego that I finally managed to put together, and that's a Sith TIE fighter. I hope there are many Star Wars fans here as well. I'm a big one since the 70s and since the first movies. And you could do me a favor, if you have really watched to this point, in your comments, if you write anyway, or just write a comment with this, just mention the word Sith in your comment, and I will know that you have seen this part of the video and have really had a lot of stamina to go through this. But let's continue with the video. Nevertheless, the deadline should be observed. Anyone who ignores Brexit or waits in vain for an adequacy decision without taking their own precautions risks high fines. For violations of the regulations on third country transfers of the GDPR, fines of up to 20 million euros or 4% of the total annual turnover achieved worldwide, depending on which amount is higher, can be imposed. Although the German data protection authorities are chronically overloaded, Brexit, which is so publicly present, is being closely monitored. So if you hope that the data protection authorities will not act, you are probably looking for the wrong event with Brexit. And if you now want to support my channel a bit further, there are the possibilities of becoming a member of this channel right here on YouTube or a patron on Patreon. The links are in the description. There's the button where you can subscribe to my channel. I hope you already did that. And if you are interested in more global or European politics right now, YouTube has chosen another of my videos right here for you on the end screen. I'll see you in my next video. I hope for many comments of you. Click and enjoy. Viel Spaß.